At this stage, I'd like to let you know that we are about halfway through the course, so congratulations. You now understand how the concept of privacy came to be. You understand the origins of the term privacy. You are starting to understand how the Indian courts have treated privacy in India right from the days of our freedom as a democratic republic down to the current day and age in the Puttaswamy judgment. And you are very well aware of the fact now that privacy is a fundamental right under the Indian Constitution. There's a fair bit to know already. And I think it's a good time to jump into looking at the laws that govern privacy in India. Primarily, there is no one single statute that governs privacy exclusively in India. As per current law, Section 43A of the Information Technology Act is the only act that comprehensively covers informational privacy in India today. By comprehensive, I don't mean to say that this provision provides an entire framework for the manner in which privacy is governed, because the provision of under Section 43A of the Information Technology Act is fairly limited in its scope. However, at present, that's the only law that we have for informational privacy in India today. So what we're going to do is take a look at the framework for privacy protection under the IT Act, as it's known. And after doing that, we're going to look at the prospective laws that may come to govern privacy very soon in India. This is the Personal Data Protection Bill. It's a draft bill that was created through a committee of experts under the chairmanship of a retired judge, Justice Sri Krishna. So let's start with taking a look at the IT Act first. So what is the Information Technology Act? The IT Act, as it's commonly known, is the primary law that deals with cybersecurity, cybercrime, and electronic commerce in the country. It was notified in October of 2000 and has been in force ever since. We are primarily going to be concerned with Section 43A of this Act because this is the provision that governs informational privacy and it's the protection of personal information in the country right now. A set of rules that were notified in 2011 have been issued under Section 43A of the Act, and we'll be coming to those once we take a look at the meat of Section 43A. So Section 43A basically provides that any body corporate who handles, processes, or deals with sensitive personal data or information in any computer resource that they own, operate, or control, they are required to implement and maintain reasonable security procedures and practices. Any failure to implement these reasonable security procedures and practices results in liability on the part of the body corporate that's involved, and they have to pay compensation to the person who has suffered as a result of this negligence. So that's essentially a civil liability. Section 43A clarifies that by reasonable security procedures and practices, what's meant is that body corporates must ensure that there is no unauthorized access to the sensitive personal data or information that they have. There can be no damage. There should be no modification, disclosure, or impairment of the sensitive personal data or information that's involved. Now, let's break this down into sizable chunks to understand what the purpose of this provision is. Let's say that you are the user of a social media company and you part with certain sensitive personal data. We'll come to the technical meaning of sensitive personal data or information as defined under the rules that are notified under Section 43A in just a minute. But for the purposes of simplicity, let's just take one of the most common examples of sensitive personal data. That's financial information. It's sensitive because it's something that you keep confidential. You would rather not share it with a third party because of the consequences of its misuse. So let's say that you are the user of a social media company and you part with your financial information. You give them your credit card details to get access to a particular game that you really enjoy. The social media company takes your details with the caveat that it will only use these details for the purpose of providing you access to that particular game and for no other reason. A couple of months pass, you have enjoyed your game, but you also start to notice that there is some suspicious activity in your bank account. You rush to your bank only to find out that there is withdrawals of money that you have not consented to or authorized from your bank account, and subsequently you start to see that there's been a disclosure of your financial information through this particular social media company. Now, what this means is, in the terms of Section 43A of the IT Act, is that the body corporate or the social media company in this case has violated its obligation to maintain reasonable security practices and procedures for the sensitive personal data that you have handed over to that social media company. Why is it a negligence in maintaining those reasonable security practices or procedures? Because it's a disclosure of that sensitive personal data or information without your consent. So in this case, if the violation is proved, you will be able to get compensation from the social media company, because that's their liability for violating the requirement of Section 43A of the Act. In order to understand the legal framework within which this protection of sensitive personal data operates, it's important to also take a look at the rules that have been notified under Section 43A of the Act, which is what we're going to do now. Rule 3 is an important rule. It defines sensitive personal data or information for the purposes of the Information Technology Act and these rules. There are 6 categories of sensitive personal data or information, SPDI, as it's commonly referred to. The first is passwords. The second is financial information, such as debit card, credit card details, or payment information. The third is your biometric information, so fingerprint scans, retinal scans, that sort of thing. The fourth is any information relating to your sexual orientation. The fifth is any information relating to your medical records. And the sixth and final information is information relating to your physical, physiological, or mental health. If any information that falls under these 6 categories of data is collected by a body corporate, then that body corporate is required to comply with the requirements and obligations laid down under these rules and Section 43A of the IT Act, so long as they're located in India. Rule 3 of the SPDI rules also clarifies that information that is made public through the RTI Act or otherwise publicly accessible information obviously cannot be sensitive personal data or information. So if you would be the kind of person to publicize your financial information, although I do not recommend that as a good practice, you would find it very difficult to file a complaint against a body corporate that is negligent with regards to that same financial information, because it would not qualify as sensitive personal data for the purposes of Rule 3 of the SPDI rules. Rule 4 of the SPDI rules provides that body corporates must provide a privacy policy to those who provide sensitive personal data or information to them. This is the reason why a lot of the companies' websites that you access online at the very top or at the very outset explain to you that there is a privacy policy that you must agree with, or in some cases it's not necessary to agree with it, but they at least notify you of that privacy policy. And what this privacy policy is required to inform you of, as per Rule 4 of the SPDI rules, is that it must tell you the kinds of data that's being collected, it must let you know of the purposes for which that data is going to be used, and it needs to tell you of the reasonable security practices and procedures that are being complied with for the protection of that sensitive personal data or information. So what are the rules that actually lay down the legal framework that body corporates must follow when they collect or process or otherwise use sensitive personal data or information? It's a mouthful of a name, so pay attention. It's the Information Technology Reasonable Securities Procedures and Practices and Sensitive Personal Data or Information Rules of 2011. They're commonly referred to as the SPDI rules because SPDI is an abbreviation for sensitive personal data or information, and that's what we're going to be referring to these rules as. These rules were notified by the Department of Information Technology that functions under the Ministry of Electronics and Information Technology on April 2011, and they've been in force ever since. A couple of things to keep in mind. These rules only apply to body corporates and persons located in India. So foreign companies that have no base in India or are not located in India need not comply with these rules. Rule 5 of the SPDI rules provides the guidelines that body corporates need to follow while they are collecting information from users or any other customers of their platforms. So it places the following requirements. Number 1 is that the consent of the provider of the sensitive personal data or information must be given. This consent can be given either in written form, through email, fax, or electronic communication. The second requirement is that the information that is collected must be used for a lawful purpose. It must only be collected to the extent that is necessary for that purpose, and the usage of that information must be only for the purpose for which it is collected. In addition, this information cannot be retained for a period longer than is necessary for achieving that particular purpose. I know this is a little long-winded, so let's break it down. Let's say that you are in an agreement with an e-commerce company to provide you certain services for which you are paying them certain amounts of money. And for making that payment, you're giving them your financial information. Now, let's say that the e-commerce company tells you that in order to provide its services, it also needs your location, your daily location, and it needs some amount of your medical information. In order to determine whether the collection of this information is meeting the standards under Rule 5 of the SPDI rules, you need to take a look at this requirement that we just spoke about. So, number 1, is the information that's being collected for a lawful purpose? Let's assume that it is for a lawful purpose. It is lawful for an e-commerce company to contract with a user for providing certain services. So we're okay there. Next requirement, it should be necessary for that purpose. Now, let's say that the purpose in this case is payment for services, right? For services rendered by the e-commerce company. Now, in order to pay an e-commerce company for the services that it is rendering to you, you need to give it money for which you need to provide it access to certain percentage of your financial information. It is not necessary for you to provide your location or your medical information or data to this e-commerce company unless it explains to you why it is necessary for achieving the purpose of your paying that e-commerce company. So in all likelihood, this collection of medical data and your location would not pass the test of needing the information to be necessary for the purpose for which it's being collected. The third test, the information collected shall be only used for the purpose for which it is collected. This is really important as well, because what this means is that the financial information that you are giving to the e-commerce company can only be collected so long as it's meant for the payment that for the services that they are rendering to you and for no other purpose, right? So tomorrow that e-commerce company cannot come back to you and say, well, you gave me access to my financial information, to your financial information, and now I'm free to use it whenever and wherever. They're prevented from doing that due to Rule 5 of the SPDI rules. And also very importantly, this information cannot be retained for a period longer than is necessary. So once the payment has been transacted, that information need not be stored with the e-commerce company anymore. And that of course is a sign of relief for the customer, you in this case, because you now are aware that your financial information was given only for a temporary period for a particular purpose. It was only used for achieving that particular purpose, and once that purpose is achieved, it is no longer stored with them, so that poses no risk to your financial data. The next requirement that body corporates must comply with is that they must ensure that the person who is providing information is aware of the fact that information is being collected, the purposes for which it's being collected, and who is collecting and retaining that information. So let's go back to the fact situation that we just discussed right now with the e-commerce company. The company is required to make you as the user who is contracting with the company for certain services aware of the fact that your information is being collected. Your financial information cannot be collected without your knowledge of it. You also need to know the purposes for which it is being collected. So you must be notified of the fact that your financial information is being collected and that it is being collected for a particular purpose. You also should be made aware of the agencies who are collecting and processing that information. The next obligation that body corporates must comply with is that they must retain the information for no longer than is required for the purposes for which the information may be lawfully used. It's an iteration of the storage requirement that we just discussed. All persons who are providing sensitive personal data or information to body corporates must be given an opportunity to review the information and correct it if necessary. Now, let's take an example. Let's say that you shared your data relating to sexual orientation with a particular company. And let's say that this information was incorrect, either due to a lapse on your part or by the company involved. You are notified of this lapse and you want to make a change on this. Rule 5 of the SPDI rules makes it incumbent on the body corporate to give you that opportunity to change that information. So it is, if you go to the body corporate with this complaint and say that this is incorrect information, I'd like to change it, that opportunity should be made available to you. Next, before the collection of the information, the person who is providing that sensitive personal data or information should be given an opportunity to not provide the information sought. So you cannot forcibly take information from anybody. Okay, as a body corporate, you need to give the other person from whom you are collecting information, sensitive personal data or information, an opportunity to not provide that information. Of course, there will be consequences for not providing that information, but that does not mean that you take it without informing them and without letting them know that they have this opportunity to not give this information. The body corporates, of course, have an obligation to maintain the security of the information that's provided. That is, of course, the general obligation under Section 43A as well. And the last requirement under Rule 5 is to designate a grievance officer. The name and contact details of this grievance officer should be available on the website of that body corporate. And this grievance officer is responsible for addressing grievances of customers, basically people who provide information to the company on an expedited basis. So let's go back to the fact situation with the e-commerce company again. And let's say that you've given your information relating to sexual orientation. Sexual orientation is a category of sensitive personal data or information under Rule 3, something we just discussed a few minutes ago. So you find out that this sexual orientation data is incorrect and you want to go back to the company and let them know that you want to review it. You want to make use of your right to review it and correct that information. So how you will do that is you will go to the website of that body corporate. You will find the name and contact details of the grievance officer, which the body corporate is required to do under Rule 5, and you can contact this grievance officer and solve your problem. So that's Rule 5 for you. Pretty interesting. Okay. Rule 6 of the SPDI rules provides that body corporates must seek the prior permission of people who give them sensitive personal data or information before they disclose their information. However, this prior permission is not needed if the information is requested by the government or by any other third party who's authorized to collect that information by a lawful order. Rule 8, which is the last rule under the SPDI rules, lays down the standards for reasonable security practices and procedures. And it recommends implementing international standards such as the IS and ISO standards while processing and collecting data for body corporates. It also provides that an audit shall be carried out for reviewing the data security practices and procedures for all body corporates at least once a year. So with this, we've closed out our review of the Information Technology Act and the rules that have been issued under Section 43A of the IT Act. And this is the current state of the law on informational privacy and data protection in the country. We're now going to move on to what could be the future law governing data protection for the country as a whole, and that's the Personal Data Protection Bill. Before we do that, we should step back a little and understand where this bill came from, what are the origins of this bill, what was the conversation that took place before this bill came to be drafted. And that's what we're going to do now. So we've just seen that the major law governing data protection, privacy in India right now is the Information Technology Act, specifically Section 43A and the accompanying rules under the IT Act. But although we don't have an exclusive law governing privacy in the country right now, this doesn't mean to say that we haven't thought about privacy as a country or drafting a privacy legislation. In fact, conversations around drafting a privacy legislation have taken place since 2010 in the country, when the government released an approach paper on privacy. And 2 drafts were in fact released on privacy legislations in 2011 and 2014, but nothing came of those drafts. It's actually in July 2017 when the first big step towards drafting a national framework for data protection and privacy took place, when the government set up a 10-member committee of experts to review privacy laws around the world and draft a data protection bill for the country. This committee of experts was set up under the chairmanship of a former judge of the Supreme Court of India, that's Justice B.N. Srikrishna. So this committee was constituted in July of 2017. An exact month later, the Puttaswamy judgment was delivered by the Supreme Court of India, declaring privacy to be a fundamental right. So using this judgment as its guiding principle, the committee of experts released a white paper for public consultation, laying down certain questions on key issues for privacy and data protection. And this white paper was released in November 2017. In July 2018, about a year after the committee of experts was constituted, the committee finally released its final report after taking into consideration all the public responses to the white paper that was released in November 2017. And this final report was submitted along with a draft bill to the Ministry of Electronics and Information Technology. And that's the draft Personal Data Protection Bill of 2018. Now, this draft bill is very important because if it is enacted, it's going to introduce a sea change in the way privacy and data protection are governed in the country today. The IT Act represents perhaps 5 to 10% of the scope of everything that the Personal Data Protection Bill covers. And if this is enacted, it will mean big changes for companies, for citizens, you and I, in terms of how we perceive privacy, in terms of how we understand and value our own personal data. And so it's very important to understand the key provisions of this bill. So that's exactly what we're going to do now. Start?
Let's check the sound coming or not.
Okay. So we've just seen that Section 43A of the IT Act and the accompanying rules are what govern data protection and privacy regulation in the country. That is not to say that the government has not contemplated a more comprehensive privacy legislation for the country. In fact, in 2010, the government considered an approach paper to data protection and privacy. And since then, we've actually had 2 draft privacy legislations. One was released in 2011 and the other was released in 2014. Nothing came of these drafts, but another big step, and this is what's significant for us, was taken in July 2017 when the government constituted a committee of experts. 10 experts were selected to review privacy laws and principles from around the world and formulate a data protection framework for the entire country. This committee of experts was constituted under the chairmanship of a former Supreme Court judge, Justice B.N. Sri Krishna. About a month after the constitution of this committee, the Supreme Court passed its judgment in Puttaswamy in August 2017, as you know, which declared privacy to be a fundamental right. Using the judgment as its guiding principle, the committee of experts then formulated a white paper, which it released in November 2017. The purpose of this white paper was to put forward essential questions on privacy and the regulation of data protection to stakeholders and ask them for their responses. Once these responses were received, the committee of experts got to work on preparing its final report and recommendations on a data protection framework for the country. And this report was finally submitted to the Ministry of Electronics and Information Technology in July 2018, along with a draft bill. And this bill is what we're going to be looking at in this section of the course, and it's the Personal Data Protection Bill of 2018. This bill is going to introduce a sea change in the way companies process data in the country, in the way citizens perceive their relationship towards their own personal data, and therefore it's essential for everybody, from the common citizen to laymen to students of the law, legal professionals, to understand the key provisions of the bill and foresee what is to come in privacy, jurisprudence and legislation in the country. So that's what we're about to do now. Now, the Personal Data Protection Bill is a fairly long document. It's got about 112 provisions. So we're going to break it down into smaller segments and tackle each segment separately so that it's not too overwhelming. So we're going to begin with first looking at the applicability of the bill, understanding who this bill applies to and where, the territorial scope and application of this bill. Next, we're going to look at the kinds of data that are protected under this bill. They're not necessarily the same kinds of data that we've seen being protected under the Information Technology Act. So that's again a significant departure from the approach that we just looked at under the IT Act and the SPDI rules. Once we're done with that, we'll look at the key actors in the data protection framework that's been formed under the bill to understand, whose data is being taken, who's processing data, and just sort of see the chain of responsibility. We'll then move on to looking at the data protection principles that are required to be adhered to as per the bill. After which we'll move on to looking at the grounds for processing personal data. I'll explain exactly what that means when we come to this section. We will then look at the data principal rights, which is in simple terms the rights that you and I as citizens will enjoy with respect to our personal data. After that, we'll quickly take a look at the transparency and accountability measures that data fiduciaries need to comply with. Data fiduciaries, it's a new term, so I'll explain that to you. Data fiduciaries are basically people who control how and why data is to be processed. In simple terms, we'll come to the technical definition in a bit, but simply put, companies that process personal data and who control the purpose for processing that personal data, those are the data fiduciaries. So these data fiduciaries are required to comply with certain transparency and accountability measures, and that's what we look at in this section. Last two sections that we're going to look at is whether personal data can be transferred outside the country, and if so, under what conditions. And finally, we'll just quickly take a look at the enforcement framework under the bill, and that's it. We're done with taking a look at the Personal Data Protection Bill. Not so difficult. Okay, so that's it. And the last two sections that we're going to be looking at involve understanding how transfer of personal data works under the bill, and finally just quickly understanding how enforcement works under the bill. So what are the punishments that non-compliance of the bill would invite, that kind of thing. And that's it. We have successfully broken down the Personal Data Protection Bill for you, and now comes the actual task of taking a look at each section, but I promise you it's not going to be too overwhelming. Alright, so let's start to understand the territorial scope and applicability of the Personal Data Protection Bill.